And to stay up to date, hit the subscribe button and the bell icon. Hi everybody, Ira Miller here with Ira Grizzard Real Estate, the Village's expert, and today I have a special guest. This is Katina Pantazis. She's an estate attorney. And so what we're going to do is we're going to talk about estate things. So when you're coming down to visit, then you'll know what you'll need to bring down if you're coming to buy a home, and if you want to put the home in an estate or whatever. But first, Katina would like me to read a little disclaimer for you today, because we want to make sure that everything that we say, is okay with maybe your attorney who possibly made up your estate for you. So today's program is a discussion of various legal aspects of elder law and estate planning, and is not legal advice and not meant to replace the advice or recommendations of your attorney. Before acting on anything discussed today, please consult your own attorney. Okay? So, welcome, Katina.
Thank you. Now,
let's talk a few minutes and tell your audience about who Katina Pantazis is.
Sure. So I'm an attorney in the Villages. I do elder law, which encompasses everything from wills, trust, to advance directives, powers of attorneys, and then, distributing an estate, probate, or distributing in a trust administration, and then also long-term care planning, which is what government benefits are available to someone who may be in need of assistance, such as Medicaid or VA, and that's pretty much me in a nutshell.
Okay, so good. So basically, a lot of times, when you come down here and you live in the Villages, this is a 55 plus community, so people are already a little bit up there in age, and so you can help them pretty much plan the rest of their life, whether it even includes assisted living or whatever, correct?
Right, and especially if somebody's coming from another state, we want to make sure that their documents are sufficient for what Florida wants. Of course, if you validly created your document in another state, it's going to be valid here. It's just whether or not it's going to be admissible to the courts, or a bank is going to follow your power of attorney if it's out of state and has language that the bank isn't familiar with or that isn't sufficient for Florida statutes. Same with healthcare documents. So it's important to have them reviewed by a Florida attorney when you become a Florida resident to see if anything needs to be updated.
Okay, so it was my understanding as a realtor that any estate that was made in another state doesn't apply to this state, and you have to redo your estate planning. So that's not necessarily true?
Not necessarily, no. I mean, we have had to probate estates that have out-of-state wills. So there are sometimes more more loopholes that we have to jump through in order to get it admitted to the court, because it doesn't have sufficient rules that Florida wants in place in order to admit it. But it is valid. It's just, do you want your family to have to go through those more fees, expenses, attorneys, court costs, time, or do you want to just update it while you have the time so that you know that it'll be seamless when you pass away? Okay,
so we definitely recommend that you get with an attorney when you come down here to make sure that there's no problems if anything possibly happens. So I know in my career, a lot of this stuff is kind of hard to talk about, because a lot of it is end of life things, and so it's kind of a hard discussion when you're talking about these things. But I have had a couple come down, buy a home in the Villages, and 6 months later, one of the spouses passes away unexpectedly. Mm-hmm. And so you definitely want to prevent anything like that. So definitely need to get with somebody like Katina, and we'll provide her information if it might be, you might want to talk to her. I'm sure they can kind of call you ahead of time.
Absolutely, yeah. So we provide a free initial consultation. We're located right next to Billy's Cafe on 441. So if you're not sure if your documents are sufficient, or if you want a second opinion, or if you don't have documents, we'd be happy to help.
There you go. So if they don't even have a will or a trust or an estate made up, I guess that's advisable, right?
Right. Yeah, you want something in place. Otherwise, it's going to be quite costly and time-consuming for your family.
Right. Yeah, we've experienced some of that too. All right, so I see you're an accredited attorney and to handle matters with the Veterans Administration. What does that mean?
That means that I have the specific accreditation through the VA in order to represent veterans in front of the Veterans Administration. So you can go on to their website to see what attorneys are accredited, and that's all it means, is that they have recognized me as someone who's able to represent veterans in front of their court.
So if you are a veteran, you may want to, have somebody who's already experienced with working with veterans and knows maybe some loopholes or all the different things that might apply specifically to a veteran, right?
Right. So specifically, aid and attendance is something that is available to a veteran or a surviving spouse of a veteran that may need assistance. And it doesn't have to be at a facility. It could be in your own home. If you need assistance, there's this benefit that you can potentially apply for and receive. It just depends on assets and income, and that's something that we'll be able to review with prospective clients to let them know if it's something we can help them with or not.
That's great. So that's a great benefit to our veterans out there. Very good. Daily, you are working with seniors and their families to prepare their estates for disabilities and their eventual passing. How does a senior or family get in a frame of mind to have that discussion? Because, we aren't always going to live forever, right?
Right. That's hard. Typically, you want to do it around a family gathering, which could be a holiday, a birthday, or family event. That makes it easier to have everybody in one place. It's not a fun topic, but everyone should be on the same page as to what your wishes are or your spouse's wishes are, so that they can, implement them when the time comes.
That's good, and I think, I can kind of speak for myself. As we get older, we start to realize our mortality a little bit more and more, and realize the urgency of doing something like this. So I'm glad there's somebody like you around for us to do. And look, I'm the biggest offender, or the biggest duck in the puddle, they might say, of not having, I don't have a will.
You need to come see me.
I'm going to come see you and get that taken care of, or a trust or anything like that. I have young children. I have a 20-year-old and a 17-year-old, and something happens to me at my age. I'm 64 years old, so I'm even coming up into Medicare and stuff like that. Right,
and I'm glad you brought up trust. So there are a lot of people in this area who already have trusts. However, January 1st of 2020, Congress passed what's called the Secure Act, which drastically affects our IRA accounts and how we can leave them to non-spouse beneficiaries. If you have a trust that is a beneficiary of that type of account, you need to contact your financial advisor or attorney to, number one, change the trust language, but number two, potentially change that beneficiary, because it could have drastic effects on how that money is left. Yes. Tax ramifications.
Interesting. So you need to get that changed within your documents. You can't just let it go and let whatever passed as of January 2020 and just let that take effect, right?
Exactly, yes. It's got to be changed, the wording. So we handle IRAs differently than other assets because it's tax deferred money. But now the laws and the rules have changed, and we need to change the trust to reflect that.
All right, so if you're seeing this, and you're up north, you may want to get with your attorney who did the trust initially. Or if you are planning on coming down and moving down here, you might want to just save that expense and get with somebody, get with Katina or another estate planner down here and get that taken care of all in one visit. So and that way you can kind of save some money rather than seeing somebody up there. You're going to have to eventually see somebody down here, make sure your estate is in compliance with Florida law. And that's the biggest reason for this video today. We want to make sure that everybody comes down and brings their documents with them, right? So you can kind of look them over if they want to get with you and see, any deficiencies that might be in there. All right, so let's talk about people who have moved to Florida. What should they do?
They should see an attorney. So just like you have to get new insurance, you have to register your vehicles, same is true for legal documents. You want to make sure they're sufficient for Florida law. And the only way to do that is to have an attorney review them and make sure they're sufficient.
Okay. One thing that comes to mind, I do obviously a lot of closings with homes, and some people bring in POAs. Power of attorneys for spouses. How does that work with an out-of-state, like power of attorney? Is that something that they might need to come and take a look at?
Yeah, so the power of attorney statute is specific to each state. So again, it's valid in the state that you created it as long as you created it validly at that time according to those state laws. So it should be able to cross state lines. However, title companies a lot of times aren't going to want to accept an out-of-state durable power of attorney document.
I've experienced that.
Right, so it's not that it's not valid. Again, it's what is that industry used to seeing, especially banks too. They want to see a Florida power of attorney document. So those durable power of attorney, healthcare surrogate, living will, all those documents should be updated to the state that you're a resident of. Okay,
so make sure that that's taken care of when you move down here to Florida. So when should somebody consult an attorney regarding an estate plan?
When you become a resident of that state, whether it's Florida or any state, all right, now's the time that you need to update or maybe create, if you don't have anything, an estate plan. In addition to that, when you start a family, you should have some sort of plan in place. Because if it's just you, I can understand sometimes people aren't worried, it's just me. If I pass away, nobody's going to really it's not going to be a detriment to anyone. But once you start a family, it becomes a lot more important that you have something in place to transition to that next beneficiary level. So it's important to think about it at least once you start your family.
You're talking to me, right? Okay. That's what I was going to ask you about. What age should somebody do it? But you're saying when you start a family, so it's probably never too soon,
right,
to be able to do something like that. It's not something you do when you get older, because that's what I see a lot of people do. They'll purchase a home in each spouse's name. But then, I might follow up with my clients just to keep my records up to date, and all of a sudden it'll say $100 sale in the property appraisers, and then all of a sudden I see trust next to it, or whatever the verbiage is when they put their home in a trust. So it seems like everybody kind of does it. When they're here for a couple of years, but you're saying should just go ahead and get it done right away.
Yeah, you want to make your passing as easy on your family as possible, and the best way to do that is to write out instructions as to what your wishes are. Right. And that's what a will is, or a trust.
Yeah.
And in addition to that, when people wait, they may not have capacity by the time they need to implement something, and that's why it's important to have the power of attorney and the healthcare documents, because you've named someone that you want to be your advocate, to pay your bills, manage your finances, make healthcare decisions. If you don't have that, now we've got to go to the court and get a guardian to start making decisions for you.
Right. So we need to avoid that for sure. All right, so what legal steps can one take to protect themselves from estranged children and family members?
So in Florida, you don't have to say, I leave $1 to Tom or Susie or whatever your child's name is if you want to disinherit a child or a family member. All you have to say is your intent. So in that document, state, I do not wish this person to receive anything. I specifically disinherit them. And then in addition to that, you're going to want, prior to executing your documents, a letter from your doctor stating that you have full capacity. Because that's one of the arguments is, well, this person didn't know what they were doing and therefore this will shouldn't be valid because they weren't of sound mind.
Right.
So it's important that you cover all bases when you're considering disinheriting someone.
We hear that in the news all the time, right? And a lot of these movie stars have children all over the place, and then all of a sudden they say, oh, he wasn't of sound mind when he changed the will and cut me out. Mm-hmm. But I guess it's important you do note that that one person does not get anything. You can't just remain silent, right? Very
important. Just like when you go to a doctor and you tell them your medical history, and that's super important for them to figure out how to diagnose you, it's super important to be upfront with your attorney about your family and the dynamics within that family. Because if you've disinherited a child in your mind, but you don't tell your attorney about that, that child could come forward and say, oh, I was overlooked, I should have been included.
Right.
So you want to make sure your intent is clear.
Right. Okay. Good advice. All right. So are there laws or legal issues unique to Florida that many seniors are unaware of who move from other areas of the country?
Yes. So the most common thing I hear is, I want to protect my house in case I have to go into a facility. I don't want the facility to be able to take control over my house. This is common up north for kids having to sell the house, or a lien could be placed on the house from a nursing home or assisted living facility. In the state of Florida, your homestead is protected from creditors via our Constitution. So that means that a certain amount of equity, I believe it's about $564,000 currently, is protected against creditors, meaning you can't have a nursing home lien against your house. Now, of course, if you get your roof done and you don't pay the roofer, yes, they can have a lien against your house because they perform work on the house. But any other creditor, medical bills, nursing homes, they cannot lien against your house. So that's very specific to Florida.
And that's why O.J. Simpson moved to Florida, right? So there's a good example for you. That's the one that just comes to my mind right away.
Yep.
Yeah, he came down here, bought him a home in Miami, I think, just to avoid all those creditors. Mm-hmm. So, okay, so let's take a scenario which is probably being played out 100 times of the month in the area. Mom and Dad are in their 80s and both have been doing great. Dad suddenly dies and Mom begins to struggle with living alone. Maybe Dad had been covering for Mom's short-term memory lapses. They own their home and both names are on the deed, but should Mom get help in an assisted living facility? What are they to do?
So hopefully they have already prepared documents so that they've named somebody in charge should Mom not be able to make her own decisions if she doesn't have capacity. If they've done that, then they just need to contact an attorney, an elder law attorney specifically, to figure out, hey, what's the plan? How do we implement this plan? And how do we get assistance for Mom? If they have not prepared their documents like they should have, then we've got to take another route, and that is going to court to potentially get a guardian for Mom, because if she doesn't have capacity, she can't all of a sudden start making legal documents. She doesn't have capacity, so we need to appoint someone to make decisions for her.
So a child just can't step in and just, act on behalf of the mom because they're the immediate child or the immediate relative of you need somebody specific that is documented.
Designated in a legal document, yes. A durable power of attorney or healthcare document is who you need to designate your advocate, so to speak, to start making these decisions.
Because I'm thinking, if I'm the oldest of, oldest son, that if something happened to mom, I'm just going to step in and just take care of business. But that's not kind of how it works. It's
not. In fact, a lot of times people will name their oldest child as a joint owner on assets, which is a very bad decision. The reason why is you don't get your step up in basis if it's an inherited asset, but also because now that oldest sibling inherits everything upon your passing. So they don't have to include their other siblings. And
that'll cause problems.
Right. And it could potentially cause tax consequences too, because once they inherit it, let's say out of the goodness of their heart, they do want to give what they've inherited equally to their siblings, well, now they're gifting it. So it's different than inheriting it. So it causes a lot of problems.
So you get it all, and then you're kind of just divvying it up, and now you become burdened with the taxes on it.
If it's a lot of money, right? So I mean, you can currently gift $15,000 per person per year. So you could potentially, do it if it's not a significant estate. But if it is significant, you've created a big issue.
Okay. All right, well, one thing that comes to mind, I don't know, I'm sure a lot of you have seen my video on the lady that got ripped off. Her husband was taking care of all the assets and all the bills and everything, and then he suddenly passed away. And then the daughter put the mom over here in the Villages, and all these predators started calling her and selling her things that she didn't really need. And so I made a video on that went viral. So I'm sure a lot of you have seen that. And then the daughter had to come because the mom just really didn't have that mental capacity to be living on her own and dealing with these people in a stable state of mind. And she's buying $5,000 water treatment systems and adding a new air conditioner when she didn't need a new air conditioner and all this other stuff. So finally, the kids came and said, "Sell, you're coming with us." But I think a lot of that maybe could have been avoided up front. What should senior couples do right now to prevent themselves from being in an awful situation?
Plan. So see an attorney, figure out, what your wishes are before you see the attorney, or sometimes you don't even know the options until you meet with an attorney, and then put it in writing. And that's what your estate planning documents are, is putting in writing what your wishes are so that your advocates will be named for who you want in charge of finances, healthcare, and upon passing, who you want to inherit your estate.
Is that the same as a trust?
So
an estate planning document? Yeah,
an estate planning document means it's a document that plans your estate however you want it to be left. And one option is a trust. So you could prepare a document called a trust that avoids probate. So that's very popular in this area, to avoid probate. But again, if you create a trust, there's always a downside, and that is, what if you sell your house that you have in it and you want to put another house in it? You got to remember to keep adding any assets you attain during your life to that trust. Because if you forget, now we've triggered a probate because we've got an asset out here without a beneficiary.
So if all your assets are being covered in the estate planning and you don't have a trust, do you avoid probate?
Sometimes, it depends.
Not all the time.
Right, so the way to avoid probate is naming beneficiaries. So if you name a beneficiary on an asset like life insurance, retirement account.
In your estate planning?
No, with that company.
Oh, okay.
So let's say you have a Fidelity account or a Raymond James account, and you've named a beneficiary to that brokerage account. That beneficiary inherits outside of probate.
Okay.
So probate only covers assets in your individual name without a beneficiary. So joint assets, if we had a bank account together, if I passed away, you'd automatically, by operation of law, inherit it. You can also name a beneficiary on a joint or on a bank account though. So if you now have inherited that account, you could name your child as beneficiary, and then upon your passing, they would automatically inherit it. And you have to do that at the bank.
And you still have the joint account, but now it's passed, yours passed over to the child, and then the other person still has that joint account?
So the joint owner, the survivor owns it, and then they can name a beneficiary.
Okay. All right. So that's good information. You know, if you want to make sure, I know there's a lot of people that aren't even married that come here.
Sure.
And they buy, they buy a house together. They might have a joint account together. So I guess that kind of adds a little stickiness to the mix when they're not married, right? Right.
So there's special types of planning you have to do when you are in a relationship but not married and you don't plan on getting married. We have to make sure that we've implemented your plan correctly and how you wish to do it, especially if real property like a house is involved. Mm-hmm. If you own that joint tenants with rights of survivorship, you may have inadvertently disinherited your family, because if you die first, the other person automatically becomes the owner. So the way you own assets is very important.
So that's a real good reason to get with an attorney to figure out, especially if you're not married,
right,
and what terms to put that house in. Because what are there, 3 or 4 in the state of Florida?
Yeah, it's joint tenants with rights of survivorship, meaning the survivor owns it. Tenants in common, meaning your 50% goes to your estate, my 50% goes to mine. And then tenancy by the entirety is a married couple, so husband and wife or spouse and spouse. That's what tenancy by the entirety is.
And that needs to be specified at closing each and every time. And so I think the title companies kind of do that in general.
They're supposed to. So you're supposed to put the marital relation after a person's name as well as how they want to own it, but we've seen deeds come across our desk that have neither of those. So it's very important that the wording in the deed is what you want it to be, because it could circumvent your estate planning documents.
Right. So you may want to consider getting an attorney before you close on your home to make sure that it's titled exactly the way that you want it titled.
Yeah, or just seeking the advice of an attorney right before you close.
Okay. What are some challenges legally when one part of a couple becomes disabled or incapacitated because of a medical issue like a stroke?
So again, it depends, but if you have not put your documents in place, now in order to make decisions for that person, even if you're their spouse, you don't have authority to be making medical or financial decisions if it's not your individual assets or your individual rights that are being affected. So we'd have to go to the court and get permission from the court, which is petition the court to be guardian of that person, appoint a guardian, and then that guardian acts on their behalf. So the downfall of that is time and money. It's expensive to do that, and it takes a while to do that.
It does. Courts, they are slow.
Right.
They are definitely slow in making a decision. I think, a lot of these things have to be signed off by a judge, and a lot of times they have a stack of papers on their desk that it takes him forever to get to start signing these documents. I know as a realtor, many times I'm waiting for a judge to sign off on a probate document.
Yeah, homestead. Yeah.
So, and then talk for a minute that I'm kind of facing something right now where this, the people passed away who owned the home, and now it's in the estate. And there was a waiting period. I think there's a 3-month waiting period for creditors to come in. What do they have to publicly announce that they're getting ready to close on this home?
Right, so it's called the creditor period. It's 90 days or 3 months. And you have to publish notice. So typically you'll see that in the newspaper, an estate notice to creditors. And it has to run for a certain amount of time. And then that period that they have is 90 days to come forward and say, hey, I'm owed money, I need to be paid. Now the estate doesn't always have to pay every single creditor. It depends on how much money is in the estate. And if there's limited funds, then we have certain classes of creditors that get paid depending on the class. So if you're at the bottom and there's not enough funds in the estate, then sorry, you're not going to get paid. Is
there a way to avoid having to go through all that?
So there is a 2-year waiting period. If you wait 2 years, then creditors are forever barred, meaning if you wait 2 years to proceed with an estate
Okay.
or a probate.
Okay. Well, I think 90 days versus 2 years. Yeah, we're going to pass on this one. No. How important are wills?
Very important. That is, you know, when you pass away without a will, the state of Florida has your instructions written out for you that your family has to follow. So many times that's not beneficial to the family. For instance, if you have a family where there's stepchildren or children not of the marriage involved, that could be disastrous, going by what the Florida laws say you have to do in that type of situation. Or maybe you've got a child who isn't good with money, is a spendthrift, or is on disability, so can't inherit, and all of a sudden you've given them this lump sum inheritance, you've disqualified them from their benefits through the state or federal government. So it's, or maybe they've got creditors of their own, they're going through a bankruptcy and anything they inherit goes straight to their creditors. So it's very important that you put everything down in writing, your plan, whether it's a will or a trust, but that states, you know, your family dynamic, who you want to inherit, why you want them to inherit that way.
Well, that was going to be my next question was, does a trust take the place of a will? Or is there a will inside the trust, or how does that work?
So you always have a will, even when you have a revocable living trust. We call it a pour-over will in the legal community. So it doesn't take the place of it per se as a document. However, how you distribute or give your estate, if you just have a will, that's written in the will. If you have a trust, typically that's where it's written. And the pour-over will just says, anything I own in my individual name, I am giving to my trust. Hence, it's pouring the assets to the trust. And
this way you don't have to name where everything goes. It's just the trust now takes
over and then distributes it according to the trust. Right. And a trust is private, so that's why a lot of times people want to do a trust is your will gets filed with the court, it becomes public record. So if somebody finds a will that's leaving everything to the trust, well, it doesn't really tell them much.
Right.
So
that's a good way to keep it private. Yeah, that's good advice. I like that. I like keeping things private. How important are advance directives?
Very. So advance directives are your healthcare documents. And, you know, healthcare is a very personal subject.
Is that a living will?
It's a healthcare surrogate and a living will. Yeah, that's typically what we call advance directives. So during your life, an advocate for healthcare decisions, as well as end of life, which is living will. So what do you wish to happen if you're at an end of life? Okay.
All right. So those two, your directives kind of talk about how they're to take care of you in a dire situation, or whether they pull the plug, or at what point. I thought that was like a living, isn't that
living will?
Yeah. So
your living will, you actually get to make the decision today while you have capacity about, you know, pulling the plug, or, you know, do you want chemotherapy or radiation? Do you want to have dialysis? You know, all those different things. You can be very specific as to what you do or do not want if you're in an end of life situation.
How do people handle when they're getting to the point of dementia or the onsets of Alzheimer's? I mean, do they have to be declared competent to be able to make their own decisions, or what kind of happens in that situation? Is there a point in time where you know you're at a stage where you're kind of not of sound mind, and then maybe you are you able to make your own decisions at that point?
So for medical decisions, that's up to the doctor. If it's in your medical record that you don't have capacity, they're going to look to your healthcare surrogate to be making your medical decisions. Okay. But if it's not yet in your medical record that you don't have capacity, then they're going to look to you. Unless somebody such as a court determines that you don't, and then your court-appointed guardian is going to be there making decisions for you. So in a legal frame of mind, though, or frame of reference, Capacity is fluid. So if somebody doesn't have capacity one day, but they come into the lawyer's office the next and they're completely lucid, they know what's going on, they know their family, their assets, how they want to leave it, all that stuff, they're able to make legal documents. So it's a different definition depending on how you're using it.
Yeah, that's exactly what I was talking about. At what point are you able to do that? How should someone hire an elder law attorney like yourself?
So you always want to look up somebody's credentials. You want to look on, so for attorneys, you can go to the State Bar Association, so Florida Bar Association, to see if there's been any dings on that attorney's record or any complaints, so to speak. And then of course, by, professional referrals within the community, go to the professionals that you trust to see who they have used or who they, feel comfortable using. That's always a good starting point.
Good. Okay. Do you offer free, I guess you mentioned this at the very beginning, you do offer free initial consultations, so no cost to you. We're going to give Katina's information at the end of this video, so what you can do is you can just give her a call or maybe talk to Erin.
Yes,
her
absolutely.
assistant, and she'll be happy to set something up. Are these phone conversations, or are these one-on-one conversations, or how do you handle that, or both?
I like to meet in person. However, if somebody is out of state, I am able to do telephone conferences or video conferencing. So it really depends on the situation and how exigent the circumstances are. For probates, often we have clients that are not here because their parents or loved one passed away here, but they live across the world. That's fine. We e-file everything, so it's not mandatory that a client such as that be here. But if it's for estate planning, we would really like to have an in-person meeting first, and then follow-up meetings can always be over the phone. Okay, good.
Okay, so if anyone has any questions about today's show, how can you be reached? I've already talked to you about that. We'll just put your information up at the end of this. And what I want to say for myself is, look, I've had this YouTube channel for 3 years, and I haven't really interviewed anybody in particular, but I've known Katina for about 5 years now, and I really felt comfortable. She is a very good professional, and so I felt like she would be a great person to interview. It'd be great information for my viewing audience, and very helpful. So we decided to go ahead and do this. I called her up. She was very gracious and allowed us to come and interview her and provide some questions. That helps because I'm not an attorney, so I don't know all the questions to ask. That's why I have my little cheat sheet here. And look, there's also the Florida Bar. They have the lawyer referral service too, for the Florida Bar, if you want to call them up as well. But anyways, thank you, Katina.
Thank you.
I appreciate it. And if you have any more questions, you can call me. 352-454-9561. You can call Katina, 352-600-2987. So, and again, we'll go ahead and put all that up on in type at the end of this video for you. So I want to thank you again for watching. Again, if you're not a subscriber, please become a subscriber. We'd love to have you. And hit that little bell icon for instant notifications. For all the new videos that we bring out. Just talking with Katina, I think maybe my next video or subsequent videos, I might get an accountant friend of mine and talk to him a little bit about and provide some information, some accounting information for you when you come to Florida and move to Florida, see if there's anything interesting or new that you need to know from an accounting standpoint. So I want to thank you again for watching, and we'll go ahead and see you in my next video.